Good afternoon, ma'am. This is the report of Group 5, Incorporation and Organization of Private Corporations.
Section 10. Number and qualifications of incorporators. Any person, partnership, association, or corporation singly or jointly with others, but not more than 15 in number. That natural persons who are licensed to practice a profession and partnerships or associations organized for the purpose of practicing that profession may not be organized as a corporation unless otherwise provided under special laws. A corporation with a single stockholder is considered a one-person corporation. Section 11. Corporate term. A corporation shall have perpetual existence unless its article of incorporation provides otherwise. A corporate term for a specific period may be extended or shortened by amending the articles of incorporation. No extension may be made earlier than 3 years prior to the original sequence expiry date unless there are justifiable reasons for an earlier extension as may be determined by the Commission. Section 12. Minimum capital stock not required of stock corporations. Stock corporations shall not be required to have minimum capital stock except as otherwise specifically provided by special law. Section 13. Contents of the Articles of Incorporation. All corporations shall file with the Commission articles of incorporation in any of the official languages, duly signed and acknowledged or authenticated in such form and manners as may be allowed by the Commission, containing substantially the following manners, except as otherwise prescribed by this code or by special law. A. The name of corporation. B. The specific purpose or purposes for which a corporation is being formed. Where a corporation has more than one stated purpose, the articles of incorporation shall indicate the primary purpose and the secondary purpose. That a non-stock corporation may not include a purpose which would change or contradict its nature as such. C. The place where the principal office of the corporation is to be located, which must be within the Philippines. D. The term for which the corporation is to exist, if the corporation has not elected perpetually existence. E. The names, nationalities, and residence address of the incorporators. F. The number of directors, which shall not be more than 15, or the number of trustees, which may be more than 15. G. The names, nationalities, and residence address of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code.
H. If it is a stock corporation, the amount of its authorized capital stock, number of shares into which it is divided, the par value of each, names, nationalities, and residence addresses of the original subscribers, amount subscribed and paid by each on the subscription, and a statement that some or all of the shares are without. I. If it be a non-stock corporation, the amount of its capital, the names, nationalities, and residence addresses of the contributors, an amount contributed by each. J. Such other matters consistent with law in which the incorporators may deem necessary and convenient.
Section 14. Form of Articles of Incorporation. Unless otherwise prescribed by special law, the article of incorporation of all domestic corporations shall comply substantially with the following form. Article Incorporation. The undersigned incorporators, all of legal age, have voluntarily agreed to form a stock, non-stock corporation under the law of the Republic as certified the following. First, the name of corporation should be. Second, the specific purpose or purposes for which the corporation is being incorporated. Where a corporation has more than one state purpose, the article of incorporation shall state which is are the secondary purpose or purposes. Third, the place where the principal office of the corporation is to be located, which must be within the Philippines. Fourth, the term of which the corporation is to exist. Fifth, the names, nationalities, and residence of the incorporators. Sixth, the number of directors or trustees, which shall not be less than 5 or more than 15. 7. The names, nationalities, and residence of persons who shall act as directors or trustees until the first regulation directors or trustees are duly. 8. If it be a stock corporation, the amount of authorized capital stock in lawful money of the Philippines, the number of shares into which is divided, and in case the share of par value shares, the par value of each, the names, nationalities, and residence of the original subscriber, and the amount of subscribed and paid by each on his subscription, and if some or all of the shares are without par value, such fact must be stated. 9. If it be a non-stock corporation, the amount of its capital, the names, nationalities, and residence of the contributors, and the amount contributed by each, and such other matters are not inconsistent with law, and which the incorporators may deem necessary and convenient. Section 15. Unless otherwise prescribed by this code or by special law, and for legitimate purposes, any provision or matter stated in the article of incorporation may be amended by a majority vote of the board of directors or trustees, and the vote or written assent of the stockholder representing at least 2/3 of the outstanding capital stock, without prejudice to the appraisal right of dissenting stockholders in accordance with the provision of this code, or the vote or written assent of at least 2/3 of the member if it be a non-stock corporation.
Section 16. Grounds when articles of incorporation or amendment may be disapproved. The Commission may disapprove the articles of incorporation or any amendment thereto if the same is not compliant with the requirements of this code, provided that the Commission shall give the incorporators, directors, trustees, or officers a reasonable time from receipt of the disapproval within which to modify the objectionable portions of the articles or amendment. The following grounds are for such disapproval. The articles of incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. The purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. The certification concerning the amount of capital stock subscribed and or paid is false, and the required percentage of Filipino ownership of the capital stock under existing laws or the Constitution has not been complied. No articles of incorporation or amendment to articles of incorporation of banks, banking, and quasi-banking institution, pre-need, insurance, and trust companies, NSSLAS, pawn shops, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agencies to the effect that such articles or amendment is in accordance with the law. Section 17. Corporate name. No corporate name shall be allowed by the Commission if it's not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law, or when its use is contrary to existing law, rules, and regulations. The word corporation, company, incorporated, limited, limited liability, or an abbreviation of one such words, punctuation, articles, conjunction, different spacing. The Commission, upon determination that the corporate name is not distinguishable from a name already reserved or registered for the use of another corporation, already protected by law, contrary to law, rules, and regulations, may If the corporation fails to comply with the Commission's order, the Commissions may hold the corporation and its responsible directors or officers in contempt and hold them administratively, civilly, and criminally liable under this code and other applicable laws, revoke the registration of the corporation.
Section 18. Registration, incorporation, and commencement of corporate existence. A person or group persons desiring to incorporate shall submit intended corporate name to the Commission for verification. If the Commission finds that the name is distinguishable from a name already reserved or registered for use of another corporation not protected by law and is not contrary the law, rules, and regulations, the name shall be reserved in favor of the incorporators. The incorporators shall then submit their article of the incorporation and drag by law to the Commission. A private corporation organized under this code commences its corporate existence and juridical personality from the date the Commission issues the certificate of incorporation under its official seal, and thereupon the incorporators, stockholders, members, and their successors shall constitute a body corporate under the name stated in the Articles of Incorporation for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved in accordance with law. Section 19. De facto corporations. The due incorporation of any corporation claiming in a good faith to be a corporation under this code, and its right to exercise corporate powers shall not be inquired collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding.
Section 20. Corporation by estoppel. All persons who assume to act as a corporation knowing it to be without authority to do shall be liable as general partners for all debts, liabilities, and damages incurred or arising as a result thereof, provided, however, when any such ostensible corporation is sued on any transaction and entered by it is a corporation or any tort committed by such, it shall not be allowed to use its corporate personality as a defense. Anyone who assumes an obligation to an ostensible corporation, such cannot resist performance thereof on the ground that there was in fact no corporation. Section 21. Effect of non-use of corporate charter and continues in operation. If a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, its certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period. If a corporation has commenced its business but subsequently becomes inoperative for a period of at least 5 consecutive years, the Commission may notice and hearing place the corporation under delinquent status. A delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements that the Commission shall prescribe. Failure to comply with the requirements and resume operations within the period given by the Commission shall cause the revocation of the corporation certificate of incorporation. The Commission shall give reasonable notice and coordinate with the appropriate regulatory agency prior to the suspension of revocation of the certificate of incorporation of companies under their special regulatory jurisdiction.